cause. Okay, a superseding cause. Some jurisdictions use the two terms synonymously, but for our purposes, one that interrupts the chain of cause and effect is a superseding cause. Get here when you can.
So did you're saying use superseding instead?
Use superseding. If you find in your analysis that the second act should interrupt the chain of cause and effect, then you should use the term superseding. All right. Just give me the facts in dirty area. BJ?
Well, I apologize because this is one class that I was not prepared for, and this won't happen again. This is my first time having to do this semester, and I apologize.
Mr. Golden?
Which one? Sorry.
Dirty Aryan.
So
Just the facts.
the fact was that the plaintiff was working on a roadside construction site. Dickens was driving a car, had a seizure, and his car went into the construction site, struck the plaintiff. He went airborne and essentially landed in hot liquid enamel, and somehow the plaintiff survived, but obviously he had significant injuries. So he brought suit, and
Against whom?
He brought suit against the defendant, the construction company that he was working for, as well as Dickens, the driver that had the seizure.
Mm-hmm.
The person that had the seizure was essentially released, or because that was not intentional,
Unforeseeable.
unforeseeable. And so in the trial, there was expert witnesses that testified that the defendant, the construction company, did not take the reasonable precautions by creating the barriers to prevent such an accident from occurring.
Right. They were supposed to have, the main part of that is they were supposed to have either put a large piece of equipment or a mound of dirt near the work site in such a way that it could possibly have prevented something like this from happening. And so the court found here that this was not a superseding cause because the risk created, or the result, okay, of the injury, right, is the type of injury that the precautions were designed to guard against. Okay, if we look at the language, look at 345, bottom, last full, where the acts of a third person intervene between the defendant's conduct and the plaintiff's injury, the causal connection is not automatically severed. In such a case, liability turns upon whether the intervening act is a normal or foreseeable consequence of the situation created by the defendant's negligence. If the intervening act is extraordinary under the circumstances, not foreseeable in the normal course of events, or independent of or far removed from the defendant's conduct, it may well be a superseding act which breaks the causal nexus. Because questions concerning what is foreseeable and what is normal may be the subject of varying inferences, as in the question of negligence itself, these issues generally are for the fact finder to resolve. There's a check mark next to that. This is an issue of fact. Notice the overlapping here, like there's a lot of overlap, and even the notes tell us that this inquiry as to whether the intervening cause interrupts the chain of cause and effect and relieves the original tortfeasor of liability is very similar to what we talked about last week with proximate causation, right? Whether this act falls outside or inside the line where, again, and I'm going to say it 27 times today, the chain of cause and effect is uninterrupted. Moving on to 346. Second paragraph. A prime hazard associated with such dereliction, the failure to put a large piece of machinery or a pile of dirt, is the possibility that a driver will negligently enter the work site and cause injury to a worker. That the driver was negligent or even reckless does not insulate Felix from liability. All right, the resulting harm here, okay, even though it may have been negligent on behalf of the driver, does not relieve the construction company of liability. Last sentence, that defendant could not anticipate the precise manner of the accident or the exact extent of injuries, however, does not preclude liability as a matter of law where the general risk and character of injuries are foreseeable. There's a triple star right there. Now, you know, in all of these notes and all of these examples and scenarios that the editors have provided us here, it's important for you guys to keep in mind that these aren't necessarily rules of law. These are just situations where courts have decided that, you know, this falls into this bucket and this falls into that one, okay? And these, as the very first case last week pointed out, that, you know, these questions are really hard to decide, right? They're really hard to come to a determination of whether it's difficult to come to these determinations. So I'm going to point out to you the language that, you know, you want to use, the language that you want to see, but don't necessarily think of these as rules. You're going to have to think your own way through some of these scenarios when you see them in a testing context, okay? Note 2, I've got 347 circled. Note 2 talks about the superseding and intervening interchangeable. They're not for our purposes. Note 3, second sentence, a person is deemed to have foreseen the normal consequences of his conduct but is not responsible for extraordinary negligent intervening acts of third persons. Notice, extraordinarily negligent. Okay, we're going to talk about the intervening acts of criminal acts of third parties as well. So, if it's extraordinary, it's more than likely going to be a superseding cause. Note 4, one of the reasons, right, that you board up an abandoned building is to keep vagrants out, because vagrants have a tendency to cause damage, including fire damage. Okay? So the resultant injury there was part of the foreseeable risk of failing to board up the building. Note 5 is circled. Note 6. I mean, again, these are just scenarios. Note 8, I pulled that one for you and I put Wareham v. RKO on twin for you. The answer to that question is yes. Okay, yes, it is foreseeable that children during the summer who are bored, especially back before the Xbox 360 and cell phones, okay, were likely to jump in the car and race, act unreasonably in racing to chase down a disc jockey. Note 9. Note that a plaintiff's own conduct can constitute an intervening cause that breaks the causal connection between defendant's negligence and the injury. However, in order to be a superseding cause, plaintiff's conduct must be more than contributory negligence that would be irrelevant in apportioning negligent conduct. Okay? What does that mean? Anybody? So,
More than 50%?
well, I mean, in a way, right? It's almost even more than that, right? In other words, it has to be such that, it has to be so extraordinarily negligent that you wouldn't want to say, well, plaintiff was 60% at fault and defendant was 40% at fault, which is in a modified, and I don't want to complicate that. I don't want to go there, okay? But if you couldn't apportion it, and most of the fault, like it's pretty apparent that the resultant injury would not have happened had not the plaintiff acted unreasonably then that's a superseding cause. I'd hate to put a 60-40 in it. It's almost like there are instances where there's a 90-10 plaintiff, and so that's really weedy, but that's what it's getting at there. Notice here, note 10, some jurisdictions have backed away from giving a separate jury instruction on superseding cause, finding that the substance of the doctrine is covered by the proximate cause instruction. So I just talked about that for a minute, a second ago. Note 11, one standard type of intervening force is called an act of God, vis major or force of nature, force majeure. Okay? And sometimes, as the note says, sometimes acts of God or vis major are foreseeable, right? And remember the case we had where the piping, the plumbing in the city had frozen, okay? And they said that was a once in a century storm, so that was not foreseeable. The fact that there are high wind that I don't know, that we have tornadoes in Alabama, and so you need to sort of batten down the rooftops. Okay, so that would not be, that would not interrupt the chain of causation if the roof blows off necessarily.
That'd be like
in a high wind. Now, if it's a full-blown tornado, it's a different story. Yes,
the levees breaking in New Orleans
that's right.
for Katrina. I mean, that's an act of nature or act of God, the hurricane, but it was foreseeable that those could not withstand.
Right, but only if they were negligently constructed. Now, Katrina was once in a century storm too, right? You'd have a big burden of proof there that they were negligently constructed.
But what about like if you have studies or like independent studies done prior, saying, or like bridges, for example, or when you have independent studies saying this infrastructure is not built to code or it's not going to withstand yada yada yada.
Yes.
Okay.
Especially where something's not built to code for a specific reason, right? So, and then A, B, C, and D there give you examples of where it is not, well, A, B, and C are not superseding causes. D apparently is. Okay, the reason that Watson v. Kentucky and Indiana Bridge Company is here is to introduce the concept of the superseding criminal act of third party. Note that if the act is intentional, it is more likely to interrupt the chain of causation between the original tortfeasor and the resulting injury. Because generally people aren't foreseen to act in a criminal manner. Here, of course, the court makes a big deal about it could be foreseeable that when they spilled all this gas that somebody, back when everybody did what I'm not supposed to do and smoke cigars and cigarettes all the time, all right, it would be foreseeable that accidentally somebody might drop it in there. Here, drop it and ignite the gas. Here we have conflicting testimony that somebody may have heard this guy say, well, let's go blow this thing up, right? And so if he had done it intentionally, then if he did do it intentionally, and the jury found that he did it intentionally, it would have interrupted the chain of causation between the spilling of the gas. Look at 351. Middle of the big paragraph. It could not have foreseen or deemed it probable that one would maliciously or wantonly do such an act for the evil purpose of producing the explosion. Therefore, if the act of doer was malicious, we quite agree with the trial court that it was one which the appellees could not reasonably have anticipated or guarded against, and in such case the act of doer and not the primary negligence of the appellee Bridge and Railroad Company in any of the particulars charged was the efficient or proximate cause of appellant's injuries. Okay? Second clause of the next sentence. But if the intervening agency is something so unexpected or extraordinary, there's that word again, is that he could not or ought not to have anticipated it, he will not be liable, and certainly he is not bound to anticipate the criminal acts of others by which damage is inflicted, and hence is not liable therefore. Where have we seen here where a defendant has been held liable for the criminal acts of third parties? Remember the apartment complex case where they had dominion and control of the common areas, right? The part that I can't remember, Klein Avenue. That's what it was, right? Mm-hmm.
The one with the robbery?
Yeah, the one with the robbery where they said that since it was a high crime area, there had been an uptick in the criminal act or criminal activity in the area. It was foreseeable that somebody would try to break into the building, and so the owner of the building, having the means by which, or being in the best position, I should say, to make the safety improvements, should have done so in anticipation of such a criminal act. You will also see fact patterns involving movie theater parking lots, okay, where you will be given hints as to an uptick in criminal activity in the area. So while this remains the general rule, the courts have backed off of it a little bit, as Note 1 tells us. Note 2 tells us it is probably impossible to state any comprehensive rule as to when a defendant will be liable for the intervening criminal act of third person. Okay, so there can't be a hard and fast rule. And then we have more examples. Notice the parenthetical concluding the first full paragraph on 352. Question of fact for jury whether any intervening act of another is itself the foreseeable harm that shaped the duty imposed, and thus defendant who failed to guard against such conduct would not be relieved of liability. That's exactly what we were just talking about with the parking lot and the apartment complex. Note C, defendant brings into association with plaintiff a person whom he knows or should know to be peculiarly likely to commit crime under circumstances creating a recognizable unreasonable risk that he will do so. The security agency for an apartment building hired a security guard with a violent record. The guard used his passkey to gain access to plaintiff's apartment where he assaulted her. Genius. Okay, genius. All right, negligent entrustment, right? Apparently I haven't. Have we talked about the awful case about the Auburn Applebee's? No. Okay. Apparently some manager of the Applebee's somewhere in Auburn, Opelika, drugged a young female employee one night after work and ran away with her and locked her away and sexually assaulted her for 3 days, kept her on drugs and everything. So, how would a plaintiff in that situation get to Applebee's? Under what circumstances would you be able to get to Applebee's deep pockets and hold them liable for the intentional acts of their employee? Gunther?
If they knew that he had a history.
If they knew or should have known that he had any history whatsoever of acting like this. If there was no indication in his record, and they did a duly diligent inspection of his application and background. Otherwise, generally, we'll get to this in vicarious liability, generally, right, employers are not liable for the intentional acts of their employees, but only if they knew or should have known that he had any propensity whatsoever to act in this manner would Applebee's be held liable in that situation? Okay, so that's what we're talking about. That's what C is getting at here on 352. Note B of 353, defendant insurance company issued a policy on the life of a child payable to her aunt as beneficiary. Under state law, sale of such a policy was prohibited because the aunt did not have an insurable interest in the life of the child. The aunt murders the child in the hope of collecting life insurance. Okay? Yes, because type of harm statute designed to protect against. Note C, we have parents of an assaulted young girl suing Firestone because she had a flat tire in the wilderness. Okay? And some evil guy happened along and assaults her or murders her. Okay? Look at that quote. Bad people in society who do bad things was insufficient to establish foreseeability. Okay? I mean, think about that. Where is that line? Where is that line? We're talking about a tire manufacturer. We're trying to hold a tire manufacturer responsible for a murder. Okay? Where is that proximate cause line? Right? And the rest of those are examples where they were outside the line. And remember, there are too many things that have to happen, right? There are too many things that, if we talk about it in terms of what we talked about last week, there are too many things that have to happen in the interim between, say, the production of the tire and the girl happened to be in this area where this, psycho happened to be at the time the tire broke and he happened upon her. So we've got all these things and we're trying to trace all of that back to the tire company. Would that be foreseeable? And the answer to that question is no. Okay? Look at note 4, triple star, note 4, keys left in car. Okay? This is one of those sliding scale things, right? Remember we had the case where we talked about the note case where there were keys left in the car, in a running car in the winter in Wisconsin, and we're trying to heat the car up, okay? And they said in that instance, no, because that, But if you leave your keys in an unlocked car in a high crime area, right, and somebody steals that car and wrecks it, then that is foreseeable and may be traced back to the person who left the keys in the car to begin with. Okay? So that has everything to do with area. Notice parenthetical there, first parenthetical. Teenage thief testified that 4 or 5 of the cars she had stolen had ended up wrecked, and police officers submitted affidavit that stolen vehicles are more likely to be involved in accidents. Y'all hear that? That has been, it has been going on for 6 weeks. It is incessant. Half the time I can tune it out. Note 5, intervening intentional misconduct. Okay, if it's intentional, it is more likely to be a superseding cause. Okay. Note 7, the answer to that question is no. We've seen note 6 before. Note 7, the answer to that question is no. And I pulled, wait a minute. No, I didn't pull that one. No, I did pull Parness v. Tempe. It's online for you.
You said 7 was no?
7 is no. The answer to that question is no. No liability there for the intentional, because the intentional act was superseding.
You answered 9.
It does answer it, doesn't it?
Well,
If husband knew of disease because defendant's silence.
it would be if the husband knew, right?
Right. Okay, the reason Fuller is here, what we have in Fuller is we have a doctor is in an accident caused by the negligent act of another. After he hits his head in the accident. After the accident, he has depression and a series of 38 seizures in a relatively short period of time. Okay, and the reason this case is here is that, what's the issue? At issue is whether a negligent tortfeasor can be held liable for the suicide of his or her victim. And what you need to take out of this, generally the answer is no. However, okay, this irresistible impulse test that you see in this case, that's what you need to take out of it. And it does come up. Okay? The irresistible impulse. If it is eventually found that the plaintiff, by virtue of having been injured by the original tortfeasor, comes under an irresistible impulse to commit suicide, as our plaintiff here, what does he say? He says, I gotta do it. Okay? Then the original tortfeasor may be held liable for it. Okay? In other words, that chain of cause and effect, it is possible to act negligently in a way that will lead somebody irresistibly to commit suicide.
Do you have to show organic brain injury in these cases?
I don't think, not necessarily, right? I think you're gonna have to have some sort of closed head trauma. Would you have to show it? Maybe. I'm not. I'd have to think about that. We've already seen the aggravation of a pre-existing schizophrenic episode, right? Notice note 1. So that's what you need to take from there. That's your note, right? Irresistible impulse test. That's what you got to take from that. That's why this is here. Note 1 tells you what generally the rule is, and that is courts generally view suicide as a deliberate, intentional act. Okay? And note 2 discusses the evolution of the rule through the irresistible impulse. Note 3 tells us that courts are more likely to permit a claim where the tort was intentional. Note 5, apparently, generally, bad lawyering does not qualify as sufficient. Denying liability because connection between negligence and the practice of law and decedent suicide 12 hours after arriving in jail is too attenuated. Oh, notice note 6. I didn't circle it, but yes, circle it. An affirmative duty to use care to prevent suicide is sometimes imposed by tort law upon certain classes of defendants. Where is that? Where in what scenario does that happen? Psych wards, right? Suicide watch for in correctional facilities, right? Suicide watch. What was that? Is that what you said? Jails, right.
Military also.
Military also? Sure.
We had it.
Okay, you gotta put somebody, remove everything and have tearaway sheets such that, folks cannot hang themselves in cells. Okay, what are our facts in McCoy, somebody? Left side. Ms. Michael? Just the facts. Just the facts, ma'am. Stand up so everybody can hear you, please.
The Suzuki car swerved off the road and flipped over. McCoy was the plaintiff. He was passing by. He stopped the cell phone. As he was about to leave the scene, he was hit, and the car that hit him rammed. And McCoy sued a bunch of people, including, I think this one focused on Suzuki Motorsport, and alleged that their defective car was the proximate cause of the injury.
Right.
If the car breaking down, he would never got hit on the side of him.
So we are suing, we have a rescuer suing the automobile manufacturer of the car that wrecked originally. And we're at summary judgment as it pertains to Suzuki, correct? We've been dismissed Suzuki has been dismissed as a matter of law by the trial court. Notice here, and right before the rescue doctrine, okay, notice here that one of the arguments, well, actually what the Court of Appeals found is that an injured rescuer need not prove the defendant proximately caused his injuries. Instead, the court concluded the rescuer need only prove the defendant proximately caused the danger and that the rescuer was injured while rescuing. Okay, notice that the Supreme Court shoots that argument down and said you still have to prove as a traditional tort plaintiff, right? It doesn't change the burden of what the plaintiff has to prove. The plaintiffs have to prove that the activities of the defendant were not just the cause of the danger, but actually the proximate cause of the injuries. But what you want to take from this one is the rescue doctrine, right? Danger invites rescue. Okay, so it's based on what? It's based on foreseeability. That if one puts another, unreasonably puts another in danger, it is foreseeable that someone is going to stop and try to help. Okay, and therefore, if the rescuer is acting reasonably in the rescue attempt, then the original tortfeasor can not only be held liable for the injuries directly to the rescuee, but also to the rescuer. Okay? Notice at the bottom of 360. The rescue doctrine is not a common law remedy. Rather, it is shorthand for the idea that rescuers are to be anticipated and is a reflection of a societal value judgment that rescuers should not be barred from bringing suit for knowingly placing themselves in danger to undertake a rescue. I mean, this is a broad proximate cause circle here that we end up with in this case, is it not?
Yes.
Right? That the negligent manufacture of a car, right, is foreseeable that that car would wreck, and also something, that there would be a rescuer and that the rescuer would be in a certain position and that another car might come along and negligently hit the rescuer. We're going to take that all the way back to Suzuki and say that it's a question of fact. So I think this is a very wide circle, and I don't believe that I agree. Last paragraph here: we do not find the alleged fault of Suzuki, if proved, to be so remote from these injuries that its liability should be cut off as a matter of law. Certainly the alleged fault of Suzuki is not as remote as the fault of the defendants in Maltman and Hartley, and thus we must distinguish their results. And those in Maltman, what was that? That was the helicopter crash? Yeah, Maltman was a helicopter crash hundreds of miles away. And so they remand this case back to trial court. Yep.
I feel like there might have been, there was a bigger responsibility on the state trooper that just left without,
Sure.
saying.
Yep.
Left the do-gooder on the scene. And
Note 2 is a Cardozo quote.
3017. Bless you. Yeah.
The risk of rescue, if only it be not wanton, is born of the occasion. The emergency begets the man. The wrongdoer may not have foreseen the coming of a deliverer. He is accountable as if he had. Okay? I've got note 3 circled. In certain instances, the rescuer, note 4 tells us the rescuer can sue the rescuee. Okay, that's certainly true in a situation where one's own negligence, okay, has created the risk. Okay? Let's say, I'm an inexperienced kayaker, all right? And I undertake a, what do they call them? Are they categories? They're what?
Class.
They're class. And I undertake a class 5 rapid with my inexperienced self in my brand shiny new kayak. Okay? And I am cast upside down and caught in the middle of the river, and somebody jumps in to try to save me, and gets hurt in the process. Yes, that person could sue me for being an idiot. Okay? Note 5 tells us if the rescue is utterly foolish, it may interrupt chain of cause and effect. Therefore, the rescuer may not recover. And then, question of jury for the Marine hanging out with dimples in note 6. I've got 8 and 9 circled. 9 is important, triple star there. 8 and 9 on 364. 9 is important because it talks about the firefighter's rule. The firefighter's rule is that police officers and firefighters can't necessarily recover for actions in negligence that create the risk for which they were called to the scene. Be careful when you see it, because it has to be the sort of risk for which they would have been called in the first place. Firefighters to fires. Okay? Not firefighter standing behind the truck gets hit while after the fire's been hit by a third party after the fire's been put out. Okay? Incidentally, Alabama has never adopted the firefighter's rule, and by the time they got around to considering it in 1997, the court noted that other jurisdictions were getting away from it, and so not only did they not timely consider it, they then said, well, since other people were getting away from it, we're not going to adopt it anyway. Okay, so that's how it stands in Alabama right now. I looked it up because I felt like somebody would ask. Look at the very middle of the paragraph on 9. The rule operates to preclude recovery only if the risk created was the type of risk reasonably anticipated by the job. So be careful, okay?
That's a really broad statement.
Yep.
So that would be like in Alabama, if firefighters go into a fire and the homeowner doesn't have any smoke detectors or anything like that, and they can sue for negligence.
They potentially, right? It's not officially. I mean, the rationale behind the rule is that there's several. The book points out, right, that they're trained to act under emergency circumstances, and they're assuming the risk of by taking on the job to begin with, and presumably, although this is not true, we all know they're underpaid, but they're paid to take on the risk, right?
There's a pretty significant criminal side of it, though. Like if the homeowner sets his house on fire.
Oh, sure. Oh, yeah. No, that'd be different,
Yeah.
right? I mean, look at. Well, I mean, just the examples in the second half of Note 9, right? A police officer injured in an altercation with an intoxicated person armed with a knife in a bar after responding to call from bar employee barred by firefighters rule, right? That's why the policeman was called to the scene to begin with to deal with the drunk guy with a knife. And that's what he signed up to do when he went to the academy. Okay? Next one, doctor who had agreed to provide medical services at construction site not barred when he was injured and seeking to reach injured person trapped in landslide, right? That doctor signed up to treat people that were taken out of the landslide. He did not sign up to have to go into the landslide and extricate the injured person himself. So that makes sense, right?
Question.
Yes.
Does this work also when they're off duty?
No.
It's only on duty.
I thought
Only on
police
duty.
officers though were always
Huh?
police officers.
I think that'd be a question of fact, more than likely. There's no hard and fast rule there. Yes.
Did not sign up for, is there a better phrase for that refers?
He did not assume the risk of having to climb into the landslide. Primary example, look at 11, attempt to alleviate harm caused by defendant. The primary example of this is the case in which a physician treats the plaintiff's injuries and negligently aggravates them. Is the original defendant liable for the aggravation? The usual answer is in the affirmative, triple star. Okay?
Where is this?
Note 11, 365, first 4 lines. Medical negligence, is foreseeable. That somebody might mistreat an injury caused by someone else's negligence is foreseeable. That's why that's usually a yes. Look down there, about 7 lines up, parenthetical in Anaya v. Superior Court, driver liable for plaintiff's death in helicopter crash en route to hospital after automobile accident. Kelly V. Gwinnell is here to talk about what? Social host liability, okay? And the trend toward holding social hosts liable in a sort of a liable for injuries to third parties caused by intoxicated persons leaving parties, house parties, or get-togethers, right? And I think that the court and the dissenting opinion does a good job of
43 Alabama.
This 2 PhDs.
Got a little talk at halftime.
Yeah, that little chat they got at halftime, right, Miss Johnson? All right. Little pound of flesh at halftime. All right. So anyway, I think the court does a good job laying out the public policy considerations, right? If we were to impose and of course, the court here does it, and then the legislature takes it away, the note tells us. Okay, and what is a Dram Shop Act?
It's a statute or case law that makes like a bar owner.
That's right, that's a statute that makes a bar owner liable for injuries to third parties resulting from intoxicated persons driving after they leave the bar or the restaurant, okay?
Yeah, I was gonna say, I think it's important to note though, that it's not just bar owners, it's anybody that's serving alcohol for a commercial purpose.
Yes, which is why when I have things, well, yes.
A higher bartender.
Or hire a bartender, that's true.
Right.
Yes.
On this case, when they went after the homeowner's insurance, or when they went after Zach, they had been also.
You have
Would
to
you do
pay,
that because the homeowner's insurance would more likely cover the damages where the auto insurance would not?
I'm sorry, I missed the question.
When they named that the homeowner was, as a defendant,
Mhm.
would they do that because his homeowner's insurance would cover the damages where the auto insurance of the driver probably would not, since he was driving under the influence?
I don't know if that, general liability under either wouldn't cover it.
I can answer.
Good.
Most homeowners insurance have a signified line for host liquor. So as long as there's no money going back and forth, a lot of times your homeowner's insurance does cover a little bit of host liquor.
Well, how about that? Thank you, Ms. Mint. There you go. I mean, you know, when I have events, you know, when I had the social on the roof last month, you know, while I'm standing by the front door, like Uber, right? You know, Uber. Do not leave here. Yes?
But doesn't it say in here, like a homeowner, at what point is reasonable? Are you supposed to, it says it in here, I forget the reading, how he said it. He said, you're supposed to physically restrain
That's right.
somebody? What are you supposed to
Take away
do?
the-
That's right. And, you know, I'm not taking on Mr. Barnes to try to keep him from leaving, right? I'm not gonna wrestle. What?
Is there anything legally that you can instruct in writing, like a waiver or something like that?
The waiver, that can waive no,
Nothing that they can sign?
no, saying that I, well, I mean, that would be evidence too, but it wouldn't be dispositive. Yet, we're spending way too much, we got way too much to do with this, right? This is a public policy argument, yes.
No, I was going to say, so you could probably call the police, report it, then it relieves you. You say they're on the road, they left wrong.
Yeah.
Not gonna be a
That'd be great for your social life.
Legally drunk after two drinks, they can't do that.
That's right, and the notes and the dissenting opinion, you know, addresses that, right? At what we're putting the burden on, you know, presumably bar owners have been trained to recognize when someone is sufficiently intoxicated. You know, we may or may not know that as lay people, okay? But anyway, so that's the public policy arguments, Dram Shop Act. Note 6, commercial dispensers of liquor, there's the Dram Shop. Employers, yes, Christmas, you know, the Christmas party, you know, from Wolf of Wall Street, okay, is a thing of the past, okay? And there's one of my favorite words in the torts class, note 9, negligent entrustment. Okay? Yes, you can be held liable for handing your keys to your drunken buddy who just wants to go get more beer. Okay? Don't do it. I'm just going around the corner, man. Enright v. Lilly, right? We're not going to hold Eli Lilly liable, right? That would draw the circle to why? Third generation liability, right? It would be too much of a burden on the research and development of pharmaceuticals. All right, that one you can figure out. Note 2, 376, is emergency room doctor liable to the friend who brought the patient for treatment for not telling the friend to be tested for meningitis? Right, and here's the quote, right? Here's the quote where the courts are talking about how difficult it is to make these calls. The court is once again in a familiar place defining legal duty in a negligence case, in particular determining where to fix the limit, where is the line of a doctor's malpractice liability for professional advice allegedly given to someone not his patient. This sort of line drawing, a policy-laden determination reflecting a balance of competing concerns, is invariably difficult, not only because it looks in part to an unknowable future, but also because it is in a sense arbitrary. Remember Judge Andrews in Paul's graph last week talking about this is not logic, this is not law, this is public policy. Okay, these lines are arbitrary. Hard to explain to the person just on the other side of the line, especially when grievous injury is alleged. Human compassion and rigorous logic resist the exercise. If this person can recover, why not the next? Yet line drawing is necessary because in determining responsibility for negligent acts, common law courts must look beyond the immediate facts and take into account the larger principles at stake, including the need to limit the legal consequences of wrongs to a controllable degree. Okay?
Told you have to tell the patient to tell their partner or people they've been contacted to.
What's that now? I'm sorry.
I understood that you have a duty to tell the patient to warn the people
The
they're
friend.
in contact to or their partner who they're in contact with. And if you don't do that, then you've reached your duty.
Okay, there you go. You're under duty as the physician. What
Your
Dr.
duty
Dale is
is
saying.
to the patient, but to tell the patient to warn people in their circle.
Yeah, she's saying that the duty to warn is, your duty is to the patient, but you need to tell the patient to warn the friend, right, that they need to be
For an
tested.
STD,
Right,
you know,
or an STD, or,
warn the patient.
why you gotta bring sex in it?
Everybody's going.
Yes?
Now they're back. Dean, in my experience, money is the consideration for the contract of liability in healthcare. That's how we look at it. The duty doesn't extend past the contractual requirements.
Right, and that's
You pay
what-
me, I bill your insurance, my duty's to you, but not to a third party.
Right, and that's what that's what the case is saying, right. And note 3, has a series of no's, okay, a series of denying liability. Note 4A allows the court allowed that case to proceed. Note D is, 4D. All right, should an attorney be liable to the intended beneficiaries of a will? That is the most likely scenario where a third party will be able to collect from an attorney for negligently creating a trust document. Notice in Note E, this case, Sanchez v. Walmart Stores was in the book, the Duncan book, that I decided to go back to the process, but dram shop liability to pharmacies for the negligent dispensing of opioids. There was a no there.
But they are sued.
That's right. I did pull in 5B, Rice v. Paladin. The First Amendment should not preclude liability. I put that up there for you guys to read on Twin. What do you think about E? Right? When these shows, Springer, Jenny Jones, they're not, right, create these, potentially explosive emotional situations, where it is foreseeable that somebody will lose their you-know-what,
That's why he's got.
right? Do you think that Jenny Jones should hold some liability for these situations, right? Especially when they are creating these situations for their own financial gain?
And they should know that there should be considered to be possible reaction.
That's right. I mean, you're springing things on, no pun intended. Okay.
But don't they have to sign a waiver or something?
I'm sure they do.
That's why he's got.
But that's still not gonna alleviate. I mean, I still don't think a waiver would relieve. I'd like to read that thing.
Yeah, me too.
My guess
Right.
is that they need more than they're potentially going to lose, so it's worth it.
Yeah, well, I mean, there's a cost benefit analysis for sure.
But I mean, they know what they're doing when they go in there, right?
Look at, all right, so 380, look at note, what is 2, they're changing the second paragraph there. Quote, this position has been justified, many torts teachers have found it helpful to express foreseeability in terms of the risk idea. Quote, this position has been justified as more rational since the factors which define negligence should also limit liability for negligence, as easier to administer since it fixes the nearest thing to a definite boundary of liability which is possible, and more just since negligence may consist of only a slight deviation from the community standard of conduct and even be free from all moral blame, while its consequences may be catastrophic and out of all proportion to the fault. Okay? And I've tried to phrase this stuff for you in that way, right? When we talked about going back to Calemus, right, which is not what these cases are saying, right? What the Calemus was the plank that fell into the hole and the ship blew up, right? So that small act of negligence, right, simple negligence, ended up being what would be categorized as catastrophic because the whole boat burned. Okay? Note 3, all right, tells you what you should have learned from this chapter. You are not expected to be sure of the answer for all cases, but you should identify fact patterns in which application of the principles of proximate cause have become fairly well crystallized. For example, within skull and rescue situations, social host liability, and third-generation DES plans. And then I've got the first paragraph on 382. Starred as well. There's a majority rule stated on 384 you need to know right there in the middle of the last paragraph. In Spicer v. Ozenkoya, the court noted that other jurisdictions consistently have held that the original physician is not liable for the negligence of the specialist unless the referring physician had reason to know the specialist was incompetent, knew or should have known. All right, on to joint tortfeasors. Y'all want to take a quick break? No? Okay.
Do you want to take a break?
No? All right, Brzezinski is here. All right, to talk about action in concert. Two tortfeasors acting negligently in concert. Both, in those instances, both tortfeasors are jointly and severally liable for the entirety of the injury. Okay, what's the argument here? The guy that's the defendant that's trying to get out of this is saying what? Well, I didn't hit her. He did. Right? My car didn't make contact with the plaintiff's car. So why am I being held liable? But the community of action, acting in concert, right? Both were equally negligent, and therefore both equally created the injury. Note 2 discusses joinder. That is a concept that you will see in Civ Pro. Okay, that's where, let's say here that, where were our two? Race and Brzezinski were our two defendants, right? If, if they had just sued Brzezinski could have joined Race and pleaded Race into the action or cross-complaint against Race. I don't want y'all to get bogged down with that. That's one drawback of having Civ Pro in your second year, but you will see it. Next year. 3, most jurisdictions, while permitting the plaintiff to join multiple defendants in the same action, do not require that the plaintiff do so. The plaintiff has the right to sue one tortfeasor alone without joining others who also may be liable. And as you see here, if that happens, then what the defendant who is named, right, can cross-claim third-party complaint the other person they believe to be also liable, even though the plaintiff did not join them to begin with. Note 4, 387, joint and several liability means that tortfeasors can be sued jointly with the others for the amount of the plaintiff's loss, and that each is also individually liable for the full amount of plaintiff's damages. The plaintiff can collect from any one of them or any group of them. We've talked about that, right? Any one or any group, and then it's for the group to figure out who's responsible for what in these situations. Okay?
How do they apportion us? What's the process by which they apportion the damages amongst themselves?
Well, in a joint and several liability scenario, they don't, right? You can, let's say you had $100,000, right? And one person, and one of 3 defendants is the only person with the money, right? That defendant is going to be responsible, and then he can go after, that defendant can then sue the other 2 for what is a contribution for their part, right? It's a wholly different thing. It's a wholly different cause of action. Note 5, there are 3 types of factual situations in which joint and several liability usually is imposed. The principal case illustrates the first, that in which the tortfeasors acted in concert. Note B is important, and it does come up the last 3 lines in Note 5B. The mere presence at the commission of a tort does not render an observer liable as if he were a participant. Moreover, right, the presence at the commission of a tort does not imposes no duty on the bystander to prevent the tort either. Okay? The presence at the commission, the presence at the commission of a tort imposes no duty on the bystander to try and prevent it. Okay? General. Okay, in the next 2 cases, in Coney v. JLG and Bartlett, we see 2 sides of the same coin. The first one, from Illinois, asks whether the doctrine of comparative negligence or fault is applicable to actions or claims seeking recovery under well, that's not the question that we're concerned with. Whether the doctrine of comparative negligence or fault eliminates joint and several liability. Okay, so comparative negligence, we have contributory negligence jurisdictions and comparative negligence jurisdictions, right? In a comparative negligence jurisdiction, there are 3 types of those, and we'll get to those when we get to defenses next term after Christmas. But in a contributory negligence jurisdiction, and you can see it here that the court discusses it, right? Contributory negligence means what? If the plaintiff is 1%, traditionally under the common law, in a contributory negligence jurisdiction, if the plaintiff was 1% liable for or responsible for his or her own injuries, then they were barred from recovery.
So it's all or
Okay?
nothing?
Huh?
Is it all or nothing then?
No, it was all or nothing.
Oh, well,
Okay? And we'll talk about that when we get to it. And there are ways that the court sort of tried to work around that because of the harsh results. Okay, but 46 now of the other jurisdictions, of which of course Alabama is not one, have adopted comparative negligence whereby the allocation of the fault, however many defendants, negligent actors there may have been, and whether the plaintiff acted negligently, is given to the jury, and the jury allots, this defendant was 60% liable, this defendant was 20% liable, and the plaintiff was 20% liable. Okay? And so the question here is, for the Illinois court in Coney, is if we have adopted that comparative negligence paradigm, what does that do to joint and several liability? And in this case, the Illinois court said it does not eliminate it. Okay? And the rationale is on 390. In return for allowing a negligent plaintiff to recover, right? They talk about a quid pro quo of moving away from contributory negligence into comparative negligence. In return for allowing a negligent plaintiff, right, to recover, this court said fairness requires that a plaintiff's damages be reduced by the percentage of fault attributable to him. Were we to eliminate joint and several liability as the defendant advocates, the burden of the insolvent or immune defendant would fall on the plaintiff. In that circumstance, plaintiff's damages would be reduced beyond the percentage of fault attributable to him. We do not believe the doctrine of comparative negligence requires this further reduction, nor do we believe this burden is the price plaintiffs must pay for being relieved of the contributory negligence bar. The quid pro quo is the reduction of plaintiff's damages. Okay, perfectly reasonable way to look at it. Don't you agree? Okay, equally justifiable and reasonable is the New Mexico court's opinion in Bartlett, who says it does do away with joint and several liability.
Can contribute
In a comparative negligence jurisdiction.
in a comparison.
In a comparative negligence, not in contributory. It always is in play. It always is in play in a contributory negligence scenario.
Depends on the-
But it depends on comparative negligence. Depends on the jurisdiction.
Okay, so joint and several liability is always in play and contributory.
In a contributory negligence jurisdiction. That's right.
Of which there aren't very many anymore. Of which there are not very many anymore.
There are either 4 or 5, but you're sitting in one of them.
Well, how important is that?
It's very important. Right? It's very important. Because let's say, seriously though, let's say that, I don't know, let's say that if we went to a jury and there was ample evidence that a plaintiff was at least 25% at fault for their own injuries, right? If we didn't have the workarounds that we're going to talk about, last clear chance, and others, okay, then that plaintiff is, even though the defendant was provably 75% at fault, that plaintiff is denied recovery altogether. You get nothing, right? You get nothing. And so yes, it's a very big deal. Whereas in a comparative, just say it was if it had been a pure comparative negligence jurisdiction, even if the plaintiff had been 25% at fault, we have $100,000 worth of injury, right? At least then the plaintiff would be able to recover 75. In the contributory negligence, you don't get anything, nothing, okay?
Can you say again how the joint and severed liability comes into the comparative negligence statements? The jurisdictions?
Right, that's what these two cases are about.
One does and one doesn't.
Right, one does, there's a difference of opinion. In other words, there's a difference of opinion.
The first one does, second one does not.
That's right. First one does, second one does not.
Is there a reason Alabama hasn't evolved to the?
That is a very, very, very loaded question. Is there a reason that Alabama hasn't evolved? That was her question.
It's called Republicans.
Yeah, no, I mean, there's no particular reason, right?
I got a question.
Yes.
What exactly is a scintilla?
A scintilla is an iota. How's that? You like that? One big word for another. No, a scintilla is just the slightest bit of evidence.
Yeah, that's what I was talking about.
Right, the slightest bit. Look at like the fifth full paragraph of 392. The second ground is that joint and several liability must be retained in order to favor plaintiffs. A plaintiff should not bear the risk of being unable to collect his judgment. We fail to understand this argument. Between one plaintiff and one defendant, the plaintiff bears the risk of the defendant being insolvent. On what basis does the risk shift if there are two defendants and one is insolvent? In our case, the risk factor arises because the concurrent tortfeasor, 70% at fault, is unknown. Okay? I've got 393 circled, and this is just a further discussion of the same things. Look at the first sentence of note 2 on 393. Defendants in states that adopted comparative negligence urged that the concept of comparative negligence should be applied to compare the negligence of the defendants to each other, as well as to compare the negligence of the defendants to the plaintiff, and that each defendant be responsible for only that part of the injury that the percentage of fault apportioned to him bears to the total negligence of all tortfeasors. Okay? And again, we're not going to, just want you to understand joint and several liability and how it may be applied in contributory negligence jurisdictions and comparative negligence jurisdictions. Not going to be a whole lot of this on the final, okay?
I found this to be some of the most confusing content that we've read. I'm still trying to understand it.
Does this make the plaintiff a tortfeasor?
Yeah, I mean, if the plaintiff, I mean, potentially, right? I mean, not legally, but I mean, in a way, right? Because the plaintiff has contributed to his own injuries, okay? By his own negligence, by his own unreasonable conduct has contributed to his injuries. So in a sense, yes, but not technically. I mean, not, you see what I mean? Look at note 7 on 394. What if the non-party is identified but immune from suit by the plaintiff? Should that be treated differently from non-parties who were not joined for other reasons? Right? Why is the company in the example there immune from suit? Note 7, page 394.
Because he removed the protective places and they were keeping safe.
No, wait a minute. The company did.
Oh, okay.
Why is the company immune from suit?
It's workers' compensations.
Workers' comp, right? You can't sue in negligence. You have to sue under the workers' comp statute. Very good. Okay, Bunt v. Embro, 396. There can be, I mean, y'all listen, we'll look at the notes, but listen. An injury begets a certain amount of damage, okay? That can be compensated, they can be calculable, and we'll talk about that. Or they can be estimated, okay? But whatever that injury is worth, there is one satisfaction associated with that injury. Okay, so satisfaction is not a judgment, it's the payment, it's the total payment of the worth or the value of the injury. All right, and there can be only one of those. You can have several judgments, but only one satisfaction. Okay? However, if it's $100,000 that injury is worth, then however you get to that $100,000 is fine, but that's it. Okay, you're not going to get any more than that. All right, there are certain situations, as the notes point out, where the plaintiff will derive the benefit of the system, the collateral source rule in certain instances. Okay, but there is only one satisfaction. Here in Bunt, what happened? New York paid the full, the state of New York paid the full amount of the damages, the full value of the injury. And so the other defendants were released. Okay? Look at the second full paragraph, 397. The Court of Claims determined that the state was negligent and the plaintiffs were awarded judgments for the injuries sustained. If defendants are joint tortfeasors with the state, the fact that the judgment satisfied is a Court of Claims judgment should not prevent application of a rule which prevents double recovery for a single injury. Okay? And you see a lot of language here in the next few pages, next several pages, about an indivisible injury. Like we've got one injury. Okay? We don't have a situation where we talk about in the notes later where we have a leg broken in one instance and an arm broken in another. Okay? We have a single injury that is worthy of one satisfaction. Note 2, suppose the plaintiff is unhappy with the amount of damages set by the first court and does not collect on that judgment. Maybe the basis of an appeal, okay, a direct attack, all right, but a collateral attack by filing another suit in another court may be barred by collateral estoppel grounds, all right. That's a fancy term for issue preclusion that y'all don't know about yet, so I'll stop talking.
Can you explain how that works? Like in Alabama, you can stack policies, so you get paid out for your injury.
You can stack uninsured motorist policies.
Right. So you put that, you would be getting paid out for one injury multiple times.
No, no, you're only going to get the amount of, that's only if your injuries are over the policy limit on one policy. Right, you can roll on to the next one. If you've got a $25,000 UIM policy and your damages are $15,000, that's one satisfaction. You're not going to be able to stack them all. Right? Now, if you had two UIM policies and your damages were $75,000, then you can stack them to get 50 of the 75. See what I mean? Note 3. Plaintiff was entitled to only one compensation, and that full satisfaction of his claim by full payment would prevent its further enforcement. That's what we're talking about here. Note 4, a necessary corollary to the rule that there be only one full satisfaction of a claim through satisfaction of the judgment was that any partial satisfaction of the claim must be credited to other parties who are also liable. Okay, and you see there in italics, pro tanto reduction, or reduction on a percentage basis. I've got all of these circled on 398. What if the settling defendant has not paid the settlement amount by the time of the entry of judgment against the non-settling defendant? Then no credit is given. If the money hasn't been paid, nothing has been satisfied, and therefore it doesn't count. Yeah, I've got all 398 circled, even though it's not really tested. It's just things that you need to think about. Like, what if, it's note 7, what if the jury's allocation of fault does not match the amount of the settlement? If the plaintiff makes a particularly good bargain in settlement and the ultimate percentage of negligence attributed to the settling defendant is less than the amount of the settlement, the plaintiff will benefit by the excess amount, just as the plaintiff runs the risk of a low settlement. Okay? Note 10, payments made by the tortfeasor's liability insurance company are of course made on the tortfeasor's behalf and therefore credited against the judgment. However, at common law, payments that were not made by or on behalf of the tortfeasor are not credited to the benefit of the tortfeasors, even though this means plaintiff may receive more in compensation than he suffered in losses. Okay? That means if my cousin, who is a doctor, treats my injuries because he is my cousin, right? That does not inure to the benefit of the defendant who caused the injuries to begin with. And so that is a situation where I may not have to pay for the compensable injuries, the treatment for the compensable injuries, but nevertheless, the defendant is still responsible for the full cost of those injuries.
So do they get a discount, like if the family member treated?
Yeah, but that doesn't. The point is there that is absolving a negligent defendant of responsibility for his acts. That's the approach there. Okay, so if my good fortune in having a cousin that is a doctor should not relieve them of any liability for my injury.
So let's say my bill would have been $100, whether I went to the doctor down the street or my cousin. That means I get $100 in the end of the case?
That means if that injury was worth $100, that the defendant still has to pay you, even though you didn't have to pay your cousin.
Okay, thank you.
Okay?
But you should buy your cousin nice dinner.
Yes, but you have to take the cousin out to dinner.
Whatever.
Like Chick-fil-A.
Whatever.
Okay, release, right? Cox is here to say what? There was a line in a settlement that said, do we have a quote? All right, the plaintiffs reserve the right to sue any other person or persons against whom they may or have or assert any claim on account of damages arising out of the above described accident. Ruled that it therefore barred any action against the defendant as a joint tortfeasor. Okay, so they had settled with goodwill for $2,500, and so there's a difference here. A release is what? A release is, I am going to release you from responsibility for these claims. Okay? Even if you are liable, I'm releasing you from your liability. Y'all have seen those. Severance agreements all have them, right? Okay? All right. Now, a covenant not to sue does not extinguish the right. It does not do away with the cause of action. It is a contract, okay, upon which the plaintiff is agreeing to the defendant that even though this cause of action still is lurking out there and is still maybe viable, I am contracting with you not to pursue it. That's the difference between a release and a covenant not to sue.
Can you put that in a release? Can you put a release in a consent? Can you put a release in a consent? So you have a consent to do a procedure, and but if the procedure gets infected,
You can't
do that.
You can't contract to waive your personal. Your potential incompetence cannot be waived.
Well, it might not be incompetence. It might be that it gets infected and then they come back and
Like your honey.
Yeah, no, can't do that. Look at the very top, 401. The manifest intent of the parties to a contract should always be given effect unless it be in violation of law or public policy. This is fundamental in contract law, where a contract has the effect of releasing one joint tortfeasor but expressly reserves the right to sue others who may be liable. It should not in law be treated otherwise. Note 1, distinguish between judgment and satisfaction of the judgment. Okay? Again, you can sue, you can get all kinds of judgments, you get one satisfaction. I've got 402 circled. As I was just saying, note 2, distinguish between satisfaction and release. Satisfaction is acceptance of full compensation. A release is a surrender of the plaintiff's claim, which may be for only partial compensation or for no compensation at all. And then note 3 distinguishes between a release and a covenant not to sue. I just did that. Okay? Note 5 lays out the variation among the states. Note 6, in some jurisdictions, a release of the negligent agent, like the driver in an automobile accident or the doctor in a medical malpractice action, also releases the principal who is vicariously liable for the agent's conduct. There is disagreement among that, right? If I release the negligent Domino's pizza deliverer, am I also releasing any claim against Domino's? Right? I don't know why you would do that. Note 8. Suppose there is only one tortfeasor. A release is signed on the basis of assumed injuries. It turns out that the injuries are actually much more extensive than assumed. Ordinarily, the plaintiff in this situation must seek to set aside the release on the grounds of fraud, mistake, duress, or undue influence. Most courts will not permit a plaintiff to avoid the terms of the release if the mistake is about the extent of the injury or its consequences. Note 9 is about general releases. Note 10 is a cautionary tale about giving lawyerly advice. All right, Elbauer, this is about a Mary Carter agreement, right? A Mary Carter agreement is where a plaintiff with multiple defendants settles with one defendant, okay, or two defendants, And then those two defendants participate in the prosecution of the action against the third. Okay? And again, this is a jurisdictionally specific thing. All I want you to do is remember what a Mary Carter agreement is. Okay? What's that? What, you want me to define it again? Well, it's defined after the ellipsis on 405 in the first 6 lines. That's all you need to know, right? Enters into a settlement agreement with one defendant and goes to trial against the remaining defendants. Okay? In my view, I struggle with this. I think that it creates a conflict of interest, and too often, it just doesn't happen a lot, but it leads itself to I think it leads to collusion, and often puts certain defendants at a unfair disadvantage. Yes.
Dean, was this similar to the fact pattern from last year's mock trial? Like, we brought that up a few weeks ago, that settled over here, then brought suit against the doctor.
Oh, I didn't realize. Is that, well, yeah. Well, but that in that scenario, well, that's certainly a possibility where it would have worked. They didn't set it up that way, but yeah, where you settled against the driver, and then the driver would have participated against the doctor. Sure, yeah. Okay. Look at the footnote on 405. The majority of cases and commentators define Mary Carter agreement as one in which the settling defendant possesses a financial stake in the outcome of the case, and the settling defendant remains a party to the litigation. I think it leads itself. I disagree with the dissenting opinion here. I think I agree with the majority opinion, and I think that while juries may be able to figure it out, it's iffy. I think it leads more to collusion than not. But anyway, all I want you to know is to remember what it is. Okay? In Nell v. Feltman, we have an automobile accident. Involving a taxi cab owned by Feltman and operated by a cab driver, an employee, as a result of which Mrs. Langland was seriously injured. Langland was riding in the car with one Kenneth Nell. After answering, what I was talking about earlier. Feltman filed a third-party complaint, a cross complaint. Okay, filed a third-party complaint as defendant against the driver husband. Nell argued that the contribution should not be available because plaintiff passengers had not alleged that Nell was a joint tortfeasor with Feltman. And here, what happened? So, the court then awarded judgment in favor of plaintiffs against Feltman for $11,500, and upon payment of this by Feltman, judgment in favor of Feltman against Nell for $57.50. The question is whether the court can compel contributions by a joint tortfeasor, and the answer is yes. Even though, the defendant, Nell here is arguing what? Nell is arguing that the plaintiff didn't name me, and therefore I shouldn't be involved in this, right? Just because they didn't name me. The problem is what? That by virtue of the third-party complaint, by Feltman suing Nell as a co-defendant, or impleading, we call it joint, or, well, it's a separate action. I don't want to get down into the specific pro of it. But at some point, Feltman proved that Nell was 50% in that third-party action. Feltman proved that Nell was 50% at fault, and therefore Nell could not get off the hook. Okay? So the answer to the question of whether a joint and severally liable defendant can be compelled to contribute, the answer is yes.
Is that the joinder thing?
Yes, sort of, yeah. The third party is not really joinder. That's what I don't want to get down into. Last sentence. In other words, we adopt for the District of Columbia, without exception or reservation, the rule stated by Chief Justice Groner in the Georgia's radio case that when the parties are not intentional and willful wrongdoers, but are made so by legal inference or intendment, contribution may be enforced. Notice in note 4, as jurisdictions on 411 now, as jurisdictions recognize contribution among joint tortfeasors, they apply a rule of allocation by analogy to contribution among sureties on an equal division basis. In other words, if you didn't have a special instruction, because you didn't have a special instruction saying allocate this percentage of fault to this defendant and this percentage of fault to the next defendant, okay, then two defendants were 50%, each 50% liable. 3 were a third percent liable. 4 were 25% liable automatically. Now, and since we have comparative negligence jurisdictions, what do we got? We've got assign, if you find, assign this amount of fault to defendant 1. Assign this percentage of fault to defendant 2. Okay, so we're moving away from that. Note 6, keep in mind that contribution is neither necessary nor permitted in jurisdictions that have eliminated joint and several liability. Why have they eliminated joint and several liability? Because of comparative negligence. So they have those special lines. That's just another way of saying what I was just talking about. Yellow Cab Company here stands for the proposition that one must, in order for one to seek contribution from who may be a joint tortfeasor. Here we have a spousal immunity issue, okay, where the wife was suing the cab company, and the cab company tried to bring in the husband and say, well, he was negligent too because he was driving negligently when the accident happened. He needs to contribute to this award, right? But the problem is, in the District of Columbia in 1950, whether it's still the case or not, a wife could not have a cause. Spouses were immune from suit by the other spouse. Okay? This stands for the proposition here that because there could have been no cause of action between the wife and the husband, the defendant cab company was not entitled to a contribution. Makes sense, right? Note 1, most states agree that non-immune tortfeasors may not seek contribution or indemnity from those who are immune. Note 413, in most jurisdictions, a party who is sued for negligence may file a cross-claim for contribution if plaintiff joined both tortfeasors, may join and plead another person as a third-party defendant from whom he is seeking contribution, or may bring a separate action for contribution. Okay? That's the separate action for contribution scenario is like when okay, you have two defendants, one has money, one has insurance and has money, one doesn't. You get $100,000 from the one, and if they hadn't joined them at the time you get the judgment, and they go ahead and satisfy that judgment, then they can turn around and sue the other party, the other tortfeasor. I've got 5 and 6 circled as well. In Slocum v. Donahue, what we have is a, Donahue was backing his truck up. He had been drinking. He was backing his truck up out of his driveway. He runs over the neighbor's child, killing the child. So the defendant, the Donahues, then filed a third-party complaint against Ford Motor Company, alleging that there was something wrong with the floor mat that was at least partially the cause of the fact that the car revved up and backed over the child. So the plaintiffs and Ford entered a settlement agreement providing that Ford would pay $150,000 to Slocum's in exchange for a release of any claim as against Ford. Okay? And then, so the Donahues argued, wait a minute. Yeah, so they settled with the plaintiff, and then Ford moved for summary judgment as against the Donahues who filed the third-party complaint and then joined them. Okay, and so since they settled with the Slocums, then they wanted out of it altogether, leaving the Donahues by themselves. Okay, and the Donahues wanted out as well, or wanted money from Ford if they lost, and the court said no. Look at what is 2 on 416. Indemnity, on the other hand, allows someone who is without fault, compelled by operation of law, to defend himself against the wrongful act of another, to recover from the wrongdoer the entire amount of his loss, including reasonable attorney's fees. Indemnity is permitted only when the would-be indemnity does not join in the negligent act. This right to indemnity is limited to those cases in which the would-be indemnity is held derivatively or vicariously liable for the wrongful act of another. Back to the negligent Domino's pizza driver. Okay? Domino's could move to be indemnified for the negligent acts of its employee. Because Domino's itself was not negligent in hiring the driver. The driver committed negligence on his own. Okay, it would be a different story if there was negligence in hiring the driver. Notice at the top 417, contribution and indemnity are mutually exclusive remedies. Note 4 explains again what we just read in the principal case. Brookman v. Pena on 418 stands for the proposition that, so here we had a guy that had a wreck, and he had certain injuries here, and then he had a wreck a few days later and had certain injuries, and the second one, the question is the negligent tortfeasor in the original wreck also liable for can also be held liable for the injuries sustained in the second wreck, and the answer to that is no. holding on 419, we hold that the defendants here cannot be held liable for the plaintiff's subsequent injury, and this is so whether or not such damage can be apportioned between the two injuries. In other words, the defendant is only liable for the damage he or she causes, the injury he or she causes. Yes?
If the plaintiff would have been able to show that their injury wouldn't have happened but for the first injury, would there have been a way to recover?
Yeah, here, yes, because here we're talking about a divisible injury, right?
But if
it was an aggravation of the injury that happened prior to, then yes.
Okay.
Yes. Look at, to your question, Vanessa, down note 3 on 420. 5 lines down. What if the second incident was not independent? Driver negligently strikes pedestrian, breaking his leg. While pedestrian is lying helpless in street, bicyclist negligently runs over his arm. At the hospital, pedestrian is treated negligently by physician, aggravating his leg injury. Driver would be responsible for all injuries. Bicyclist would be responsible for only the arm injury, and the physician would be responsible for aggravation of the leg injury. See how that works?
Bad day.
Yeah. And the original tortfeasor doctrine is in quotes at the top of 421. The original tortfeasor doctrine. Because the original tortfeasor is liable along with the later acting tortfeasor for the plaintiff's enhanced injuries. I pulled Friedrich v. Fetterman for you. And then I've got 4, which discusses proof issues, circled. Okay. All right, we're done. What? You want to take a break, come back and do the rapid fire review? Huh? No break. I'm hoarse.
Do you need a break?
It won't take me 30 minutes to do this. Let's take a break, come back, and we'll go over everything really quickly.
Quick question. Do you know if Carrie is in the office this week?
We're here Monday, and that's it.
I mean, this past week.
No, she was.
Oh, okay. I thought, because I emailed her. She normally emails me right back.
No,
okay, I'll just wait.
No,
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 back.
No,
okay, I'll just